Reynoldson, how are you today?
I'm good, how are you?
Okay, it's getting at the end of the day.
I know, I'm sorry.
It's not your
It's
fault.
like the ethics, it's like we put ethics last, right?
Yeah, at the seminars, ethics are always last, so
I know it.
everybody stays.
Yeah,
Make yourself comfortable and you can start your opening remarks when you're ready.
thank you. Good afternoon, and thank you again to everyone who I had the opportunity to speak to, and those of you I didn't, thank you for reviewing my application. It was good to talk with you all again, and it's good to see you all again. I'll try not to go back over what we talked about in January, but just a little bit about why I think this particular position is one that my experience and service in the past lend themselves to particularly. And as we talked about, I've been practicing law in Iowa for 27 years, and during that time I've had the opportunity to represent many Iowans in all walks of life. And I would suggest to you that my experience during those 27 years mirrors almost exactly the caseload and the work of the Iowa Court of Appeals. I spent approximately 15 years as either the assistant or the elected Clark County attorney, and the workload of the Court of Appeals is approximately 50% criminal and post-conviction relief cases. And in my job as the county attorney, I prosecuted thousands of criminal cases, everything from simple misdemeanors up to Class B felonies. I didn't try a Class A. I sat in and assisted with a Class A, but I did not first share a murder case. But everything other than that, I did do. I also handled post-conviction relief cases at the trial level. And then after that, I had an opportunity to go to the Criminal Appeals Division at the Attorney General's office. And in 6.5 years in that office, I prosecuted hundreds of criminal appeals, writing briefs and arguing cases in this court and in the Court of Appeals. And again, approximately 50% of the cases that the Iowa Court of Appeals decides are criminal and post-conviction relief cases. And I've spent quite a bit of my career immersed in that very thing, both at the trial court and the appellate level. I also would suggest that in that role, in the Attorney General's office in particular, but also in the county attorney's office, you don't have a lot of control over what comes into your office, the number of cases. In private practice, we have a little bit more control over that, some days less than others, but a little bit more control. We had to handle in the Attorney General's office every criminal appeal that came in from all 99 counties in the state, regardless of whether or not we had the personnel to handle it or believed we had the personnel to handle it. The Court of Appeals is much the same. They take whatever comes, and they have to work as hard as is necessary to decide whatever cases come before it. In the Attorney General's office, I believe continued all during my time there to submit what I believe were high-quality product, both in writing and in oral argument, while at the same time producing at one of the highest levels in the Criminal Appeals Division consistently during my time there. And so I believe that shows that if on the Court of Appeals, I would also be able to produce effective, efficient, high-quality, high-volume work product. Approximately 21% of the cases that the Court of Appeals decides are juvenile cases. As the county attorney, I prosecuted isn't quite the right word, but I was involved in all China cases, termination of parental rights cases, juvenile delinquency cases. And then when I went back to private practice in 2013, as a form of public service, I signed up to represent children in child in need of assistance cases as guardian ad litem. I say as a form of public service because of the small amount that they're paid per hour to do that work. But I represented not only children, but I represented parents. And so I've seen it at both sides. I've seen it from the county attorney side, I've seen it from the child side, I've seen it from the parent side, these China cases and these termination of parental rights cases. I understand the importance, the critical importance of bringing a quick resolution of those cases on appeal so that the parents and the children can bring some finality and stability to their lives. The last category cases that represent the great make up the most of the Court of Appeals are dissolution cases. During my time in private practice, I've represented any number of folks in dissolution cases involving highly conflicted custody cases, high asset cases, child support cases, I've done those on appeal as well as at the trial court level. So again, I'm intimately familiar with the issues. And also, again, in those cases, with the importance of bringing as quick as possible finality, a final result to those folks so that they can move on with their lives. In my experience, I've found that the failure to be able to move on because you don't have a final result injects so much more controversy and conflict into a family. So it's important that that conflict end as soon as possible by having that result. As you know, the Iowa Court of Appeals is a high-volume court. I believe in my career I've shown, both in the county attorney's office, where I handled one of the, at times, the highest per attorney caseload of any county attorney's office in the state, and also in my work in the Attorney General's office with a high-volume practice, that I'm able to, and willing and desire to produce high-quality work at a high volume as needed. And I find a personal satisfaction in doing that, internally in doing that. I think that skill is crucial to a Court of Appeals judge. In addition to my legal work, I also believe that my work in the profession and my community shows that I have a commitment to improving access to justice to Iowans and the delivery of that justice to Iowans. And I think it's important that whatever level judge you are, district court, magistrate, Court of Appeals, Supreme Court, that you continue to do that to the extent you can. We need to make sure that our Iowa citizens see judges as people. And I had some pretty good mentors in that. In my father-in-law and some of the other folks I've been around, I was blessed to practice law with two gentlemen who have been on the district court, who also continued their activities in the profession and in the community. And I think that's crucial, and I would intend to continue to do that as well. So, in conclusion, I think the organizational skills that I have, my concise and succinct writing skills, my ability to take a record, produce a result, apply the law, and do that effectively, efficiently, and quickly would be a benefit to the Court of Appeals. I also believe that I prefer to work collaboratively with people. And I've discussed this with some of you, and I never desired to be a sole practitioner. It's not who I am. It's not what makes me thrive, what makes me tick. When I was county attorney, it was the closest I ever was to being a sole practitioner. And the only reason I survived was because I had a husband at home who was also a lawyer, who I, in effect, then was not a sole practitioner, because I could bounce anything and everything off of him that I needed to. That makes me a better lawyer, and that's the way that and so I think that the appellate court appeals to me in addition to many other reasons because of that, the ability to work with other people who I respect so much and grow from them and help them as well in reaching decisions. So with that, I would appreciate any questions you have.
Thank you very much. We'll start with Ms. Pearson over there.
Thank you. Thank you for being here. Thank you so much for your application. When we spoke, one of the topics that we discussed was bringing visibility, education to the public just regarding the court system, the Court of Appeals. And you had some interesting thoughts and suggestions. Obviously needs to be balanced with the workload, but would you share with all of us maybe just your thoughts on some opportunities to expand and educate individuals about the court?
Well, I think it starts with each one of us individually, and again, these are all things that me not sitting on the Court of Appeals, easy for me to say that's what can be done, but I have spoken to some of the Court of Appeals judges about whether or not there is the opportunity and the time to be able to be involved in community and professional activities, and I've been assured that there are, and that's just a personal choice, and I'm not suggesting that someone who doesn't want to do that should, but I appreciate the fact that because I want to, I can. So for instance, Judge Mullins keeps an office in the 8th Judicial District and in one of the courthouses, and he routinely sits in that office. And I think that is so important, and that's what I would like to do, because it doesn't, if the public sees you as a judge just mulling in and out of the courthouse, you're talking to the janitor, you're talking to the court staff, you're talking to the district court judges, to the attorneys who are practicing, you continue to be involved and know what's going on. And I think that's very important, and that's what I'd like to do. I said as long as there's space for me at the Clark County Courthouse, which I understand on certain days there would not be, but I would like to do that. In addition, I've also spoken to some of the judges about the fact that there are opportunities to do judicial education and to do public education as well. And the fact that the Court of Appeals has gone out and done some of their oral arguments out, I think is important. But any opportunity you can have to do anything like that, for instance, the Bar Association is doing the People's Law School, and they do that here in Des Moines, but I'm working with them through the foundation to expand on that and take the People's Law School out into the counties outside of Polk County, and I think those are great opportunities as well.
Thank you.
Ms. Bowden?
Yes, thank you. In your application, you indicate that you've worked with a lot of litigants who are self-represented, do not have attorneys. What challenges do you see facing the court, and what could be done to help these people?
I think that's a huge challenge for the appellate court, but also particularly for the district court and district associate court. And I think the Access to Justice Commission, which I was on until recently, is working on some things for that. And there are some, when we started on the Access to Justice Commission, we were told not to think about money, just think about ideas. Well, at some point you've got to start thinking about money. But there are some great ideas that some other states have used as far as assisting, whether it's kiosks or whether it's persons that are stationed in the courthouse who are court employees who are assisting pro se persons. I also, through Iowa Legal Aid, have started a project, or not myself, but assisted in putting together a project to bring attorneys into the courthouses to help pro se litigants do child support worksheets. You know, all those things have to work together, and you have to be involved in that, and so those are some of the things I think should be done. Thank you.
Mr. Berger? Mr. Diaz?
Could you let us know whether you've applied for district court positions, and if not, your reasons?
Okay. I applied for a district court position decades ago, years ago. Has been a long, long time. And the reason that I have not applied for district court positions in the more recent past is that as I've matured in my practice and as I've had different experiences professionally, I've determined that the district court position is not one that best fits what I could bring to it. And I don't think, I think those positions, in my judicial district, 5B, we have 9 counties. We have 3 district court judges for 9 counties. So those positions should be filled by folks, in my opinion, who desire to do that type of work and who believe they bring the best attributes to that type of work. And I believe my experiences and my personal attributes, again, the collaborative working, not wanting to be a sole practitioner, that is better served on the appellate court and not on a district court. So that's why I have not applied. I do believe that it should be that at the appellate court level, there's a broad range of experiences. And it's not necessarily that you should go from one to the next to the next. Because while being a district court judge is a good experience to bring, there are other things. There are other ways to get those kinds of experiences rather than just through becoming a district court judge.
Ms. Law?
No questions.
Mr. Bevel?
What would you tell us about your involvement with legal aid?
When I first started practicing in 1992 in Osceola, Dennis Gronenboom spoke at our swearing-in ceremony, as he does, well, now he's retired, but as he did, I think, for 25 years or more at every swearing-in ceremony. And he was rather persuasive in not only speaking to us, but he also was persuasive in getting the court to allow him to give the form out to everyone who was sworn in to sign up for the Volunteer Lawyers Project, right? And I signed up, and I was hooked. And so then Dennis put me on, or asked me to serve on the board of the Volunteer Lawyers Project, which has morphed a little bit since then. And that just kind of evolved into eventually serving on the board of Iowa Legal Aid and as its president. I I believe my role in that position has been to advocate for legal services to rural Iowans. And I felt that if someone who was not from my area or any other rural area, but my rural area was not there, that voice would not be heard. So that's what kept me going and and keeps me involved as I continue to serve on the board.
Thank you.
Ms. Sinclair?
No questions.
Ms. Diekma?
You obviously have a tremendous amount of experience with the appellate courts. My question to you is well, you haven't been there. If you were chosen as a Court of Appeals judge, how important do you think that conference with the other judges would be in your decision-making?
Crucial. I would never believe that I know enough to make those decisions alone. And that's why, frankly, serving on an appellate court appeals to me so much more than serving on the district court, because I grow from those conversations, they grow from those conversations, I hear things I hadn't thought of, and having that kind of interaction just energizes me, the thought of having those kinds of interactions with folks. And on the Court of Appeals, you get to constantly switch from panel to panel to panel, and so you're constantly being exposed to people who've had different experiences, not only professional experiences, but life experiences. And bringing all of that together, I think, is one of the most crucial parts of an appellate court decision-making.
Thank you.
Mr. Goodman?
Thank you, Your Honor. Thank you for your application. You've had a tremendous number of appeals, 240 looks like, and then they have this sole and chief, and you've been the lead counsel in every instance, and in 3 you were sole, and all others you were basically there with another lawyer but taking the lead, correct?
No, I struggled with how to answer that question, because in the Attorney General's office, the Attorney General's name is on every appeal. But the Attorney General doesn't work on any of the appeals or have any involvement in any appeals. So I didn't feel comfortable just saying that I was sole counsel. But I had no one else other than myself on all those appeals.
That's the impression I got. I just didn't know what the difference was between sole and chief. And then you served as Clark County magistrate?
Correct.
Okay. For about a year.
Yes.
Okay. And then as county attorney for a 4-year period, that was an elected position.
Correct.
Okay, did you run for re-election?
I ran for re-election in November of 2006, and I was not re-elected. I made a decision in the summer of 2006 that I was going to, spring of 2006, that I was going to run as an independent as opposed to running with a political party. I still believe that that was the right decision. I believe that prosecutors should not be perceived to be political in any way, given that the power that they yield. I found out that what I did was make both parties mad and catch an opponent. At the time I made the decision, I was running unopposed, but then I had an opponent, and again, great lessons learned about communication and how I could have probably communicated the reasons why. I wouldn't do anything differently as far as running as an independent. I probably would do differently how I did it.
Okay, thank you very much.
Mr. Bloom?
No questions, thank you.
Ms. Conover?
No questions.
Mrs. Robert? Ms. O'Brien? Mr. Harbach?
No questions.
John, we got you. Mr. Gray?
I have no additional questions.
I don't have any questions either. We really appreciate you coming down here, and we wish you the best of luck.
Okay. Thank you all.
Thank you.
Thank you.